All right, good morning, or actually good afternoon. Not sure if I want to be the last presenter of the afternoon and between you and lunch. Not a good place to be. But I got asked to come up and talk a little bit about House Bill 2597, which has now been codified into Oregon law in Chapter 269. And it amended our state's cell phone laws while driving. Okay? This happened here at the last legislative session. And we're going to talk about a few things. Go ahead and punch to the next slide. Okay. So what the law does is very simple. Prior to last year, the cell phone restriction allowed people to drive their car, and as long as they weren't texting or actually talking on the cell phone, there weren't any restrictions for any other type of activity, which is kind of a glaring loophole in the law. The legislative body amended that last year in February of last year during the February session, and effective October 1st, this became the new law in Oregon, and it's fairly strict. But it prohibits a person from using any type of mobile electronic device while driving a motor vehicle on a highway or premises open to the public. And that includes things like a Walmart parking lot. Okay, that's a premise open to the public. It's prohibited. And what that means is you can either hold it in your hand, nor can you use the device in any way, shape, or form. So it's very simple. You can't hold it in your hand, nor can you use it for any reason, okay? There are some exceptions and affirmative defenses that we'll talk about here in just a minute. So some of the definitions that are really important for you to know: a mobile electronic device, what exactly is that? Well, it's pretty much anything. Anything that's mobile and electronic. If it's not permanently installed in your vehicle, then it's mobile. And it includes any devices that are capable of text message, voice, navigation, internet access, anything like that. It includes the Garmin GPSs and other brands of GPSs that you could use. And the definition for using a mobile electronic device is using it for any of those above purposes. Texting, reading, watching a movie, anything like that is expressly prohibited. And driving. Driving is very simple, operating a motor vehicle on a highway, and the law does prohibit using these electronic devices when you're stopped at a stop sign or a traffic control device, a stoplight, or any other momentary delays in traffic, such as a slowdown or a stop due to a crash or anything like that. But it does not include a prohibition when you're stopped on the side of the road, when you're pulled into a parking lot, or you're in a parking space such as a rest area. That's perfectly fine. There are some exceptions to the law, but they're kind of weird. So you folks are primarily commercial motor vehicle drivers, but there are exceptions for public utility vehicle drivers and school bus drivers. It has to be within the course and scope of your duties, okay? And the second thing for you, particularly as a commercial motor vehicle driver, it has to be permitted under 49 U.S. code, but the FMSCR also prohibits the same conduct. It almost mirrors Oregon law. Texting is expressly prohibited under 392.80, and then mobile telephone uses are banned under 82. And again, those very much mirror the Oregon law. You can use a mobile telephone with an earpiece or a speaker or handheld-free device, and essentially one-touch communication. Okay, but in Oregon, you cannot hold it in your hand, and nor can you use it for any other type of purpose. What's interesting about that is you could feasibly receive a citation in Oregon for the violation of state law, but you could also receive a citation for the violation of the FMSCR, because we do enforce that under state law as well. Okay, so the Oregon law penalties we'll talk about in just a second, but this penalty is even more severe. Okay, you're talking about essentially $2,500 to $2,700 for a driver and $11,000 for a company. That's a pretty significant fine under the federal regulations. So there are affirmative defenses. You guys understand the difference between an exception and an affirmative defense? An exception means it's pretty clear cut on what you can do that doesn't lead to a violation of the law. An affirmative defense is a little bit different. You're still violating the law, but you have a legal defense that you could take into court and argue that you were actually operating within the law. We don't make that decision roadside as police officers. Okay, if you have an affirmative defense, that's a matter that you will probably have to take up with the court. Okay, but if you're summoning medical aid, if you're 18 years or older and using a hands-free device, and there's another part of the law that talks about two-way ham radio type situations that are very similar to this. But I do want to point out that even fire, police, and EMS are in the same boat as you guys are. We have the same affirmative defenses, which means, yes, we could violate this law while operating a electronic device while on duty and within the scope of our employment. We have to meet the same requirements you do. So this law is pretty robust. It's pretty fair and even across the board for everyone. Another exception is using a medical device, such as one of the first alert issues where you touch the button and you call for medical aid. And then the penalties in Oregon. First offense, it's a Class B violation, $265. These numbers that you see up here, these are presumptive minimums, okay? The courts can impose up to $1,000 for a first offense, okay? Depends on the circumstances and the situations. Second offense is a Class A violation, minimum of $440, the same with a first offense and a crash, okay? Third offense is where things really get serious. Third offense, within 10 years, you can be fined a minimum, mandatory minimum of $2,000, and you could face jail time up to a year, okay? It gets pretty severe at that third offense criteria. And that's pretty much it. It's a pretty clear-cut law. No holding, no using while driving. It's very simple, and the penalties are pretty strict. Said it's a very simple presentation. Any questions?
Yeah, I have a question. What's the law on interacting with your ELD device while behind the wheel?
I knew that was going to come up. Yeah, you think? Well, I'm no expert on ELDs, and I understand maybe this gentleman here can explain it a little bit better, or our ODOT representatives in the back. But ELDs, as I understand them, are permanently affixed to the vehicle, right? Although they do have a screen that's removable and that type of stuff. As long as it's permanently affixed, it does not meet the definition of a mobile electronic device. Now, the moment you take the screen out and you're holding it in your hand, it does, okay? So just keep that in mind. Is that a fair assessment from Federal Motor Carrier and ODOT? Yeah, and that's the way I would look at it as a police officer on the roadway. If you're using your ELD in compliance with Federal Motor Carrier rule, it's not a violation of this law, and you wouldn't be cited on it, okay? If you've got it up in your hand and you're driving down the road using it to enter your required information, that's a different story. But as long as it's permanently affixed, you're fine. Good question. But distracted driving nationwide is a very significant event, and in Oregon, distracted driving accounts for about 10% of the fatalities in vehicle crashes and roughly 18 to 20% of all injuries. That's a pretty serious chunk. And it is one of the 5 major driving offenses that my agency focuses on across the state. Distracted driving is probably the #1 that we focus on.
What would a driver have to do to reach a point where he or she can legally use the electronic device? Would it be enough to pull right onto the shoulder and you're sitting there with the engine running? What detail would we put?
Great question. His question is to what level or what detail would a driver have to go to meet the requirements of the law? And yes, pulling over on the side of the freeway with your engine running, the car in park or whatever the case may be, would qualify. And quite frankly, I have stopped at several vehicles here just recently on the freeway thinking the person had broken down when actually they had pulled over and were using their cell phone. And that's hey, great, thank you, have a nice day. You know, I appreciate that. But it doesn't take long, maybe less than 5 minutes. I could go out and hit the freeway and find somebody using their cell phone right away. For whatever purpose, whether it's texting or making a phone call or whatever. It's a very common violation. We do hope to have a positive impact, particularly now given that the law has some significant teeth. We've gone through some education time here through October. It's now January. I kind of think the education time period's over, so our level of citations are going to be going up. You know, I know that there was a bill pressing forward. Did the bill, I can't recall if the bill passed or not. It did pass. Okay, in that circumstance, then yes, the new law is that you must move over for any vehicle that's stopped alongside the road displaying some signs of distress. The 4-way flashes are on and things like that. If you can safely do so, or slow 5 miles below the speed limit, that's correct. Did you have something else to? Yes, there has to be some sort of sign of distress. You know, someone outside jumping up and down, raising a red flag probably would count. Yeah, good question.